Hello, ma'am. Hi. Ma'am, I think you are not audible. Sorry, you are not audible, ma'am.
I've now been unmuted.
Okay. Now you are audible.
All right.
So within 1 or 2 minutes, ma'am, we will start. Shall we begin?
Okay, great.
No problem.
And remind me how I share my PowerPoint.
I will provide you the access.
Okay.
Manoj, sir, you are already co-host, so I think you can share the same. If you could try it right now.
There we go.
Ah.
It's been a while since I've used WebEx.
Yeah, that issue most of the faculty are facing here, online teaching and all this.
How's that?
Yes, it is visible, clearly visible. Sashi sir, are you there?
Yes, I'm with you.
Okay, sir. Thank you.
Hi, madam. Good evening.
Good evening. Thank you so much for hosting me today.
We are very happy you are here with us.
I wish I could be there in person. I miss India so much.
Because last
Surely.
occasion when we planned, you were affected by corona and you were not there. So we thought that when you can join with us. Now we are happy you are with us. You can enlighten us. Thank you.
So hopefully this corona will get over soon and I can be there in person.
Surely, ma'am, we are excited. I think we have participants and surely many will join soon. So,
All right.
with your permission, ma'am, should we begin?
Perfect.
Okay. So, very good evening to one and all present here. I am Abhijit More and I am taking this opportunity to warmly welcome you all on this special lecture series on topic Mediation and Conciliation Recent Development that is organized by Maharashtra National Law University Mumbai in association with the Family Court Bar Association. Maharashtra National Law University Mumbai is one of the premier law institution in India. University has been established in year 2014 and it started its first academic endeavor in year 2015. The university disseminates advanced legal knowledge under the able guidance and mentorship of university's chancellor, Honorable Justice D.Y. Chandrachud, and under the able leadership of its Honorable Vice Chancellor, Professor Dr. Dilip Uke. MNLU Mumbai also lays emphasis on the research project, clinical exercise, legal skill training, legal research, mooting by encouraging its students to represent university in national and international competitions. We have various centers established to conduct the advanced research like Center for Arbitration, Center for Information Communication and Technology, Center for Research in Criminal Justice, Center for Clinical Legal Education, Center for Maritime Law Research, Justice ML Painse Chair in Environmental Law, and many more. The Family Court Bar Association is a professional body of lawyers that promote conciliation and secure the speedy settlement of dispute relating to marriage, family affairs, aiding the judges in the administration of justice. The purpose and aim of establishing the family court is to protect and preserve the institution of marriage and to promote the welfare of children, providing the settlement of dispute by conciliation, and the advocate of Family Court Bar Association are working hard to achieve that goal. There is a need to understand the recent developments in the mediation and conciliation, as these techniques are helping to resolve the dispute and disagreement between the transacting party by arriving at the amicable settlement through negotiation and discussion. It provides the speedy disposal of trial, economic settlement of dispute, and it is time saving. So, with this objective in view, MNLU Mumbai, in association with the Family Court Bar Association, organized this special lecture series on topic mediation and conciliation recent developments. I now invite Advocate Shashidharan Nair, President of Family Court Bar Association Mumbai, for the welcome address.
Thank you, Mr. Abhijit. Good evening, everybody. And I'm welcoming Madam Christy Harrington to India. Very lovely, warm welcome to you. And respected Professor Dilip Uke sir, respected Professor Anil G. Warrior sir, all the members of MNLU, here Mr. Abhijit, and all the members and well-wishers of Family Court Bar Association. Very happy to interact and be a part of this lecture series, because we are going to a very democratic process of the dispute resolution that we are calling as alternative dispute resolution. In short, we are telling ADR. Different mechanics, some in it, where the most advanced as well as the most democratic part is the mediation, where the parties are directly dealing and directly taking the decision, taking away all others and making the things from there. That is the best form, which is time immemorial it was there, but we are making it as an alternative form of the dispute resolution, especially in this pandemic period. We are absolutely, almost all the courts are burdened with so many suits and cases where this alternative mode is absolutely necessary and to be provided. We are very happy the MNLU has taken all the initiative to go this such a program, and we got a wonderful speaker and sharing her experience as a judge, because the mindset of a judge to deal in a matter and an advocate to deal in a matter and a common person to deal in a matter is totally different. We are getting an opportunity to get from the real decision makers. They are coming out from the judiciary and looking for the common people, common aim, common objective to resolve it, and in a win-win situation. That's the beauty, and that is the part of the mediation. Nobody is losing, nobody is gaining. Your decisions are not taken by a third party. The decision is taken by yourself. That is the beauty of mediation. I'm not elaborating my welcome speech. I'm welcoming everybody, all those who are participating from today up to I think up to 5th of the February, 15th of February, Madam is with us. We are getting the opportunity to be with you, learn from you, and give and take and share the knowledge and take our litigants as early as possible from the arena of litigation and use their time for quality work and love their family, love their children, do your work for the society. Thank you so much. I'm a part of it. I'm always there. Thank you, and welcoming Madam once again, and from the bottom of the heart, MNLU as well as FCBA is welcoming you. We are eagerly waiting for your lecture experience, your slideshows, your PowerPoint presentations, all the things. Thank you so much. Please.
Thank you so much, sir.
Thank you.
Thank you so much, sir. So, without any further delay, I would like to introduce you all to the chief guest of today's event, Honorable Christy Harrington. Miss Christy received her undergraduate degree from the Francis Marion University in Florence, South Carolina, with the BA in English and her law degree from the University of Tulsa College of Law. She was employed by the District Attorney Office in Tulsa, where she began prosecuting juvenile and adult felony cases with the limited license to practice law. Upon graduation, she remained in the District Attorney's Office, where she implemented the domestic violence case. Upon returning to the South Carolina, Christy became very active in the bar and her community. She was employed by the Ninth Circuit Solicitor Office, prosecuting the crimes against women and children. Christy becomes the youngest circuit court judge and one of the 6 female circuit judges in the state of Carolina on February 6, 2008, when she was anonymously elected by the state legislation. She was appointed to the governor's task force on violence against women as a sole circuit judge working to reduce the number of assault and deaths of women in the state. On June 30, 2018, Christy retired from the bench after serving 2 terms. She is certified Supreme Court mediator and arbitrator, owning her own alternate dispute resolution practice, Christy Harrington Dispute Resolution. She is honored to be on the American Arbitration Association Judicial Panel and the member of Arbitral Women. Christy has taught locally, state-wise, nationally, and internationally. She has been adjunct professor at the National Judicial College in Reno, Nevada, and also served as a past chair of the Faculty Council. Christy is a distinguished visiting professor at the Charleston School of Law, where she teaches variety of classes such as advanced evidence, criminal procedure, alternative to incarceration, Canadian law, policy, and she has been the faculty advisor for the Moot Court Trial Advocacy Board on CSOL since the fall of 2020. Thank you so much, ma'am, for accepting our invitation. Over to you, ma'am.
Thank you so much. I'm so excited to be here. It's a little earlier in South Carolina, but I know that it's late, getting late afternoon, early evening for y'all. So I'm going to try to keep you as engaged as I can. Please let me know if you have any questions. I'm here, I believe, 5 series, and so hopefully we'll build on the information that I share with you. But if at any point you have a question, if you'll let Mr. Moray know, and he can interrupt me, or I'm not sure how we are answering questions, but just let me know. I want this to be as interactive and informational for you as possible.
Yes, ma'am. If anyone have any question in between, he can put that in a chat box. That will be fine, ma'am.
Okay, great. And so I love mediation. I love all forms of alternative dispute resolution, and have been very honored to have spent the last, since my retirement, really getting involved in the different aspects and areas of alternative dispute resolution. What was not included in my background was I have been, as a Fulbright Scholar Specialist, to India, and have been to Mumbai and actually on the campus of MNLU in the summer of 2016. And so really I'm just excited to be part of this process, and really looking forward to hopefully an opportunity to being back on campus sometime soon. So we're going to talk today about just generally mediations, and this would be something, a topic that I would give to attorneys, practitioners, new judges, to talk to them about what to look for in mediation. And so when we think about mediation, there's various things that come to mind. And so there's typically practitioners have different ideas of what mediation is versus what your client may have, what the individuals who are participating, what a judge may have. Mr. Moray, can they put in the chat what they believe, what the participants believe would be mediation. Maybe we'll just start from a working definition of what you believe as a practitioner who is engaging in mediation in family law, what you believe that may be.
Yes, sure, ma'am. The participant are requested if in case you have idea about mediation, what mediation basically means. So you can put that in chat box, or you can directly, talk with ma'am what your idea about mediation basically means. Anyone?
I don't see anyone in the chat yet.
Right now, no one has written anything, ma'am.
Okay, well, keep me posted. I'll just go on. I'm going to help everybody out. So when we talk about mediation, one of the first things people think about is, I don't want to go to court. And so this would be a very typical looking courtroom in the US. And so people want to avoid going to mediation. So mediation is not litigation. And a lot of times people get the word mediation confused with meditation. And so we're not here to talk about meditation. And so I love this picture because it usually gets lots of laughs in South Carolina, thinking about an attorney meditating on the top of his desk. So what we're really getting towards is this concept of two parties balancing and in a harmonious way. So the definition that has been used from the United Nations Convention on International Settlement Agreements resulting from mediation is a process. And so that's what we're going to talk about today is process. And mediators are really the process managers. We are the ones as a mediator to come into the room and to control the process. We don't control the parties. We don't control the outcome. We control this process of mediation. And further, that it is irrespective of the expression used and the basis upon which the process carried out, where the parties attempt to reach this settlement. And that is really important. We're going to talk about some of the conflicts and tensions as a mediator and the processes, different types and styles of mediation, where the parties are attempting to reach an amicable settlement. And what does that mean? So I heard in the welcome address, we're talking about this preservation, preserving marriage in the family court setting and to be harmonious. And one of the things that I love and hold so dear about my time in India is this just long history of being harmonious and getting along. And so when we have this process of litigation, it's an adversarial system brought to my country and your country by the British, in which it's an adversarial system. But what mediation attempts to do is kind of take it back to the source, right? And talk about reaching an agreement that the parties have an opportunity to join and that they can reach this amicable settlement with the assistance of a third person or persons. And that's you, the mediator, right? That's me in the room, the process manager. And what is really important and really distinguishes from litigation is that the mediator does not have the authority to impose a solution upon the parties. I tell the parties, I'm just here to manage. I'm here to offer my expertise. But at the end of the day, I can't force you. That's what I did back in my previous job when I was wearing the black robe. I could impose a solution, and you may not have liked it. But in this situation, I'm placing the decision in your hands, and this is your opportunity to reach an amicable solution. So this is, if you Google mediation, you can find a variety of different explanations, but this is a really simple explanation, and I think fits so nicely into what we're going to talk about today, especially in the family court setting. So why do we want to mediate? And I heard again, we talk it. It's in India, it's in South Carolina, it's in every state that I have heard. Is we talk about this judicial backlog, that people are waiting for their cases to be heard, and that was even before the global pandemic brought the courthouse doors to a shut, and various attempts to join and not join, turn them on, close the doors, open them back up in limited capacity. So really, mediation was the natural solution to this pandemic. And I found this statistic, which I thought was, again, very helpful, that from 2015 to 2021, there was a disposal rate, a success rate of 86.5%. So of 10 cases, more than 8 are resolved at mediation. So a couple of things to take away from that is, not only does it get cases off the docket for the judge, but we go back to that definition. The parties are involved, and the parties are reaching an amicable solution. So we're not leaving, I used to say to the parties in front of me, one of you, if not both of you, are going to leave here unhappy today. I've got to make a decision based upon the law. But really, in mediation or alternative dispute resolution in almost any form, the parties are going to leave having taken the time to air these disputes and to reach a solution that works for them. So this is what, this is exactly why, and it's reflective of why mediation is so important and why we can be so successful as mediators. So I have looked, and I know that there was an India bill that was proposed that has not passed. But what I wanted to do is share with you what the rules look like for in my state, and pretty similar to most of the countries in the United States. What the rules and the purpose of the alternative dispute resolution, what we focus on is this looking at justice, looking at speed and efficiency, that it's inexpensive and it's collaborative. So again, very similar, not quite as beautiful in talking about amicable resolutions, but again, these rules are attempting to address some of those very same concepts in that previous definition. That there is a backlog. Everybody acknowledges that mediation can be used as a wonderful tool and process to avoid these backlogs, that your clients can get their cases heard and resolved in a speedy, inexpensive, and collaborative resolution. So litigation's expensive, and we'll talk about, I found an address by your Chief Justice that talks about luxurious litigation. I love that term because, and it really is on point. And I'm going to use that term from now on. I just love it because that really sums up one of the reasons, again, why mediation is wonderful. Litigation's expensive, even if you're not intending it to be expensive. There's discovery and cost of experts and time at the courthouse. And if you're in the courtroom, you're not at work. And so there's lost revenue and all of those other things. And so mediation allows for this inexpensive resolution in these actions. So here is our definition, an informal process. And so again, think about what that means. A lot of times I'll do a mediation. I might go to if I have a large group of individuals that are participating, I don't do solely family mediation. So sometimes I do large scale construction defect mediations. We may go to a hotel ballroom, or we may meet in an attorney's conference room, or I have my own conference room that will come. A lot of times the parties come, they're not in suits or dress for court. They're in jeans and a t-shirt. And so that again lends itself to this informal nature. And so people are more relaxed. They're wearing their everyday clothes, not their very best clothes, in which a third party mediator, again, that concept of the process facilitator, facilitates settlement discussions between the parties. And again, this concept of the mediator is the process manager. The settlement is voluntary. As a matter of fact, the remaining at the mediation is voluntary. Our family court rules require that it's mandatory mediation in South Carolina for all family court cases and all civil court cases. The rules require that the parties remain at the mediation and family court for 3 hours. And that was based upon a study that's really where the movement begins to occur. So the settlement is voluntary. While we may require the parties to engage in mediation, there is no mandatory.
Okay. Okay.
Do we have a question?
Okay. Okay.
Oh, all right. And in the absence of settlement, so if there's not a settlement and the parties each go their own way, they haven't lost anything. And so again, having that concept and letting the parties know this could resolve it, but if it's not going to resolve it here today, you are not losing any of your constitutional rights to a jury trial. You're not waiving anything at that point. And that really does, emphasizing that really makes the parties feel better. So who is the mediator under our rules? Is a person who acts to encourage and facilitate the resolution. The mediator does not decide any issues or impose settlement. So back to this process manager and really focus on this neutral person. And when we talk about a neutral, that means somebody that doesn't have a stake in the claim, someone that doesn't know either party, that isn't obligated to encourage a settlement or push or a settlement one way or the other. And so doing your conflicts checks and all of that is really important because that neutral has to be fair and impartial, just like a judicial officer hearing that very same case.
But ma'am, do you think any special qualification should be required or it should be there in order to become a good mediator?
So in South Carolina, and typically, and I believe all 50 states, you have to be a certified mediator, you have to undergo a 40-hour training and still maintain your proficiency in the law by taking continuing legal education. I do think that the 40-hour class, it should be required and is a good thing because it helps the mediator talk and to understand and to recognize why it's important for you to be neutral, why it's important that you're not there telling one side you need to do this and forcing and imposing settlements. And so the 40 hours also includes practice sessions. You get to try your skills in front of someone who can evaluate you and give you some pointers on whether or not that technique is good, or maybe using this one would produce better results. Did that answer that question?
Yes, ma'am, surely it is.
Yes. Any follow-up? You follow up to that?
No, ma'am, I think that is what you have just said, that 40-hour training is required in order to understand certain thing, in order to become a good mediator. And I think that is important, because if you are not educating the person how the dispute should be resolved, then obviously if he's not in a position, that will create more issue, that will leads to more problems between the parties. So I think, yes, whatever you have specified, the skill that the mediator should be having. So yes, ma'am, surely.
And we can, one of our, I'm not sure we talk about it today, but in one of our future sessions, definitely we'll talk about the criteria for selecting a mediator. And so I was a circuit court judge. I presided as a family court judge very infrequently. I did a lot of work in the juvenile division and have experience in family court, but I feel like my strength lies more with the circuit court. I have friends who have retired from the circuit bench or from the family court bench, and they were the ones who used to decide those issues. So I think having somebody also not only skilled in the skilled as a mediator, but also very knowledgeable in the subject matter is also very important. And so I think combining with those 40 hours really makes a wonderful mediator. All right, so impartial, neutral, non-decisional, neutral. We want to engage in principled negotiations. So sometimes you may have a party at the table that doesn't have counsel, but the other one does. How are you going to negotiate? How are you, as the mediator, going to ensure that the negotiations between the two parties, this mediation of this dispute, is going to be principled? You might have two parties that are at the table, both representing themselves pro se, or self-represented litigant. How are you going to ensure if one is from a lower educational background than the other? Are you going to treat the man differently than you would the woman? Are you going to tend to help the female out because you think she is weaker? All of those things need to, as a good mediator, you need to think about where your explicit and implicit biases may come from. Really good mediators have this wonderful way of communicating. And I think naturally, our litigation skills, right? Those of us who spent a lot of time in the courtroom and talking to juries and different aspects of the communities have this ability to speak to the parties, to get them communicating. And a lot of times what we'll find and with mediation is the one party just needs that other party to hear them, to listen to them. And so being able to discuss and have that listening skills and communication skills, it's really important as a mediator. Again, you want to empower the parties as a mediator. And what does that mean, right? Again, letting the parties know that this is their day, that the mediation is there for them. And in court-ordered mediation, I always ask, when I'm getting ready for the mediation, where are you on the docket? Is this case going to be called in a couple of weeks, in a couple of months, or maybe in a couple of years? And sometimes knowing that you're up against a timeline or you have all the time in the world can work for you or against you. But getting the parties at that table, the proverbial mediation table, to work together on problem solving is really what ideally you want to have in a mediation. Keeping in mind this voluntariness, and I talk about that a lot when I'm at the mediation table with the parties. This is voluntary. You get to make those decisions. And what's also lovely about mediation is, in a court setting, there's limited options of what the judge or the jury can order. But in a mediation, it's only limited by your creativity because it's voluntary. The mediator isn't forcing it. So in a family court mediation, if you are arguing about who's going to get the dog at the end of the termination of the marriage, maybe you're able to come up with something more creative, like a shared agreement or something of that nature. Again, keeping in mind that the parties are not losing anything by being there. I talk about what's it costing you today to sit in this chair and to talk about solving this problem. Most of the time, other than the cost of the mediator, but if it's through the court annexed mediation concept or community mediation center, there's usually no cost or a very low cost. So I encourage the parties, the participants, to sit in the chair and think about today's the day. Today's the day to come in and be willing to evaluate their own position and think about the other side's position. Because depending upon the nature of the case, there's this relationship that should be valued, at one time was valued, and potentially based upon how you as the mediator and how the case is mediated could continue to be valued. So, in a termination of a marriage, if there's still children, the husband and wife, the mom and the dad still have to work together to parent. And so really doing that scorched earth policy, win at all cost, doesn't solve anybody's problem because we still have to work together to parent. So keeping those things that you want to empower the parties are really, really important. So here's rule 6, and we talk about this a lot, this duty to inform. That under the cases, all attorneys, and those are the parties that are the attorneys that are representing, should fairly and objectively inform their clients about mediation and arbitration. Not that it exists or not that we have to go, but really know and explain to your client what happens at a mediation. A lot of times the client will show up and have absolutely no idea what is going to happen. And so I encourage you, if you're a practitioner, to sit your client down, spend some time and say, this is what is going to happen. We're going to go to this particular location and we're going to talk about the options, talk about what brings us here today. And you're likely going to have to listen to the other side's position. And getting your client ready to go is really important. If you're a mediator, spend the time and talk to both either the parties or the counsel to let them know, hey, have you talked to your client about what mediation is, and most importantly, what it isn't? That this isn't going to be an opportunity to shout at each other or do those things. But just having an understanding of what's going to happen is really important. Knowing, and so in most jurisdictions in the US, we have this opening statement, very similar to what an opening statement could be in a trial before a judge, a hearing before a judge. And what the opening statement is simply is that party's position and really why they think the case should resolve in a certain way based upon the facts of the case. And sometimes there might be the opposing counsel might give an opening statement that is a little more pointed and confrontational than it potentially needs to be when we're talking about having an amicable solution. But you need to let your client know that that could happen and that they shouldn't react, or if they do, they need to react and let you handle that situation. So when you are in a domestic, and the common practice in South Carolina is to not even have the parties in a domestic mediation, even in the same room ever. Same office building, but not in the same room, usually two separate ends of the building. And so the mediator would go from one side to the other. And so there could potentially be a lot of time that lapse between when the mediator comes to speak to one party to where they go back and talk to the other party. So have that conversation with your client that there's going to be some time, some downtime, and we could spend it doing certain things. So when I leave a room, I try to give an exercise or something to do for that client and the attorney, for them to have some homework to work on while I'm gone. And then when I come back in that room, they'll have something ready for me new to discuss. It may be that in your negotiations that the first offer is no offer. I'm going to give that person 0. Well, that potentially could incite your client, anger your client, enrage your client, and that client could want to walk out the door. So letting them know that this is a process, again, that word process, that this isn't just a one and you're done, that this is a journey that you're going to go on throughout this mediation, and that there may be some unpleasant conversations that are had, but that ultimately working through those to get to this end result and how we get there. So again, I think client preparation, preparing yourself, and if you are the mediator, helping the clients, the participants, be ready for anything that may follow through. So remember, you control the process as a mediator. The parties, counsel, the participants, the litigants control the outcome. And a good mediator lets the parties control that outcome. I've seen mediators take control and force the parties to go one way or the other. Let the parties control this outcome from the mediation. This is why mediation was developed. This is this concept of an alternative dispute resolution, letting the parties naturally sit through the process. As a mediator, you are setting them up for success with all these things that we've been talking about and we'll continue to talk about, but that the parties get that final decision making. So who should be at the table? And I use it at the proverbial table. You don't necessarily have to have a table. You could have a comfy chair and a sofa, but traditionally having a table where people can write, that I found to be more effective. So our rules are pretty clear who should be at the table. That the mediator, of course, has to be at the table. Kind of no-brainer, right? In order to have a mediation, you got to have the person controlling the process. So you've got to have your mediator. You've got to have the individual parties. And so whoever that may be. So in a domestic, right, husband, wife, the people involved in the marriage are going to need to be at the table. Counsel, so each party, if they have counsel, needs to be at the table. And again, I do a lot of personal injury cases that I mediate and the construction defect cases. So there's usually some insurance. So the representative who has full authority to settle the claim. So I always ask, as I'm setting up the mediation, who needs to be there? Because the individual may think that somebody else needs to be there who you haven't even thought of. So I had a mediation one time where I had all these parties, we were ready to go, and we were very close to a settlement, and the moving party, the plaintiff, said, well, I won't be able to make any decision. I need to speak to her pastor. And so that would have been somebody who likely should have been at the table, because while that was not her attorney, that was somebody who was giving her spiritual guidance with whom she would depend, and without his assent and consent to this settlement, it would not go through. So think about who needs to be there, who should be there. Also think about maybe who doesn't need to be there, and allowing too many people at the table. Too many cooks spoil the broth, so to speak. So too many people at the table could really influence whether or not you're going to get this settlement to the finish line. So I've already talked a little bit about the opening statement. So it's incumbent, it is very important that the mediator sets the tone. And having a really outlined and defined process does a bunch of things, right? It establishes the tone of the mediation. We all love to be in an organized room and know what we're going to do. You know, we knew this session was going to start exactly at 6:30. You would have not been happy if I didn't show up until about 8 p.m. So you as the mediator control that tone, that you're going to treat everybody with dignity and with respect, and that you're going to allow them to be heard. I like to take the time to describe the process and tell everybody what is going to happen, why it's going to happen, and if they need anything else to take place. Again, make sure that all the necessary parties are present. And then again, make sure that if there's somebody there that doesn't need to be there, or is there somebody there that is going to help facilitate this mediation? Talk about the determinations of issues to be mediated. So simply saying, I'm here, we're mediating because we're dissolving our marriage. There might be some other issues too. A lot of times I get called in for family court cases, not necessarily for the dissolution of marriage, but for the dissolution of the business partnership that the two people engaged in. So maybe there's some other issues that also need to be mediated that you had no idea about. We talk about confidentiality, and so having a discussion about what confidentiality is, most importantly, what it isn't, is essential. Talking about what mediation is not. A lot of my attorneys, when we're in the mediation room, they call me judge, and it's habit and it's respect out of my former position. But I tell them, and I tell the parties, I'm not here in the capacity of a judge. I cannot decide any issue in this case. I cannot impose settlement. And so really having that discussion about what mediation is not. A lot of times, again, and this is preparation of your client and good mediation relationships, telling what that expectation is really important when those people walk through the door. And determining the ground rules. So what do I mean by ground rules? Clearly, there's guidelines that the mediator has to follow. But what if you decide to put the husband and wife together in the same room? Are there anything that you need to be aware of? Determining ground rules about we're going to not talk over each other. We're going to take turns speaking. Whatever ground rules that you think. And you remember these two individuals have known each other and had some sort of relationship before they came to you, or they wouldn't be there for you to mediate this dispute. So who knows the parties better than the parties know themselves? So asking them, are there any ground rules that we need to cover, also begins to establish for the parties involved that you're listening to them and that you acknowledge that this is the process for them, that you're not just a cookie cutter mediator, and that you really understand that this is the mediation here today between party A and party B. This opening allows the parties to shift from litigation and trying to beat each other up in court to defeating the problem. And so if you can start reframing that issue for the parties, that we're not here to beat up, party A and party B. We're here because there's a problem. And let's work together, A and B, to figure out a way to beat the problem. So these ground rules. And so, you might want to have so this is a whiteboard that you can write on. I love sticky notes. You can color code them and really talk about how the process is going to flow from this point. Once problems arise, it's really difficult to go back and establish those ground rules. So being very thorough in this opening process, in this opening period of the mediation, will make the rest of it run so smoothly. So you're going to have some difficult clients. They're either going to be difficult to deal with just emotionally, or there's going to be some difficult legal issues. And so when you're talking to the mediator, if your mediator allows you to present a brief, which I do, and the rules in South Carolina provide it, that you should have that conversation with the mediator. Or if you're the mediator, have that conversation with counsel or with the clients that you'll accept whatever your limit, 2, 5, 10 pages for them to write and submit to you prior to the mediation, outlining what are the issues, what has prevented resolution prior to this mediation. And again, letting the counsel know or letting the parties know that if there is a safety concern, that you need to know that. If there's any language or educational barriers, you also need to know that. Do you need to separate the parties, or do you think the parties must be together? And then if there's any medical concerns, right? Think about if you're going to a place that is not easily accessed, if there's a lot of stairs, or if there's any issues where you need to make sure that there's food or drinks around, that that you need to know all of those things. The South Carolina rules require that the settlement must be in writing, and I highlighted in bold, the parties shall, before the adjournment of the mediation, reduce the agreement to writing and sign with the attorneys. If you don't have it, and I don't believe that India has a requirement to put the settlement in voluntary mediations in writing, know that it's just good practice. And so one of the tips that I put in is go ahead and have a draft ready to ensure that if there's certain terms you want in the writing, right? Just to use that very simple dog analogy. If you know that you want that it's a requirement as part of the agreement to have a certain item in, make sure that you start your draft. I keep a when I'm getting ready for a mediation, I go ahead and start preparing a settlement agreement just so that I can comply with the agreement. And if the parties want a more formal agreement, then you can have that party write the longer agreement. A consent judgment or voluntary dismissal shall be filed by the court after the settlement agreement. So here we talk about confidentiality, and this is one of the things that I think is so highly sought after in mediations, this concept of confidentiality. And that any mediation communication disclosed during this mediation or in preparation for the mediation shall be confidential and shall not be divulged by anyone participating in the mediation, in attendance for the mediation, except as otherwise permitted. And so in this agreement to mediate, that protects the confidentiality of this process that we're talking about, the process of the mediation. So before we begin any mediation, I have every party talk about confidentiality and have them sign this agreement to mediate that I have composed to comply with Rule 8. Know that you have to be very careful, especially in our virtual mediations now, and this was one of the challenges and kind of pushbacks early on in this transition to virtual is, well, what if somebody's behind the screen and we don't know that that person is there? How do we make sure that they are going to comply with confidentiality? And so that has been a question. We'll talk about that in later sessions. Make sure that you, as the mediator and as counsel, sign and retain the agreement to mediate. Ensure that the mediator explains what confidentiality is and what confidentiality isn't. So I talk about a lot, I use as an example, the case that a law professor, excuse me, not just a professor, not a law professor, was able, had sued his university and received a settlement. And as part of the settlement agreement and terms, he signed a confidentiality agreement. Well, he went home and explained, of course, to his family that he had prevailed and had gotten a very nice sum. And his daughter then got on Facebook or some social media post and said, "My dad just won his settlement and he got a lot of money." Well, you can imagine what the university did. The first thing was that he had violated their agreement, particularly the confidentiality, and so it voided their settlement. And so having that conversation, and how I think just black and white that is, like everybody can understand what that means. Having that confidentiality explanation really will save a lot of problems in the future. Once the parties reach a settlement, the documents are not, once the parties prepared in conjunction with the settlement and released are not for the purpose of or in the course of mediation. And so you want to make sure that your settlement documents under a rule could also be confidential. So our rule is, and it was decided in this case, is designed to protect the communications made during mediation and to protect the process. And again, this concept of protecting the process. So make sure that that was lovely. That was
Sorry.
lovely. Was that a question or?
No, ma'am. It was not the question.
All right. So just make sure that, you know, under your rules that you understand that you don't inadvertently prepare some documents that may not be covered in that confidentiality. So in September of 2021, the rules were amended to allow for virtual mediations, teleconferencing, and electronic meeting consent. And so this electronic consent, we were having a hard time. Everybody would show up and then we can't record it. So how are we verifying that people are actually agreeing to all of this agreement to mediate? And so the electronic consent was allowed. And so some mediators at the beginning of the Zoom will record just the signing of the agreement to mediate, which I think is a nice practice. But then you have to keep that in the cloud. I recommend, I have a DocuSign account. It's not very pricey. I do all of my agreements to mediate through a DocuSign account. But again, if you don't have access to that, you can just record the party's consent at the beginning of the WebEx or Zoom. So consider what works best when you're making this decision to look at a virtual or a hybrid or in person. And so a hybrid is where you may be in the room with one party and the other parties appear virtually. So I do that sometimes with a personal injury case where really the other person on this side is the insurance company. And so I will be at the office of the plaintiff, the injured person, and his counsel, and then we will Zoom, have virtually appear defense counsel and the insurance company. So think about what works best for you and your client. Are there going to be issues with any technology? There are places that still in the world that they don't have internet access. Your client may not be able to appear. Your client may not be able to make it to court. So thinking about what works best for your client. Again, considering what you want to accomplish with the mediation, do you just need a early neutral evaluation, an evaluation of this case? Do you just need, do you know that mediation is not going to be effective? And no matter how wonderful your mediator is and how wonderful the parties come, they're just not ever going to be able to get past this impasse. Or you really want, under our rules, we have before you file a medical malpractice case, you have to do this pre-suit mediation. So it's a little different, not as involved, and typically do not result in any agreement or settlement at that stage. So I show we are at the hour. So I was going to stop here since we have more time together and just ask if there's any questions. from today's lecture?
Ma'am, you said on the mediation table there should be participants, obviously the parties, then a mediator, and you also talk about the council. So, what is
Yes,
the
yes.
significance of counsel having in mediation? Means what role significantly he can play in settlement of your dispute?
It's a great question. So, by the time in the US, by the time typically a mediation the case has gotten to a mediation, it usually means that a case has already been filed with the court, which means they already have counsel. And what I have found is the parties have developed a relationship of trust with their counsel. And so having them at the table to really, because again, you're not there to give legal advice as the mediator, nor should you as counsel want your mediator to give legal advice. So the counsel serves again in that same capacity to help that individual understand, is this correct under the law? If this goes forward, is the family court going to give all of the money in the bank account to the wife? And so having counsel there to evaluate whether or not the settlement is in their client's best interest, whether or not it's a legal settlement is really important. Mr. Moray, did that answer that question?
Absolutely, ma'am. But the
Yeah.
thing is, what doubt I had in my mind, right? Like you need to convey four peoples the same thing. The council of the parties and the parties need to have mutual, settlement on the same thing. And there might be the chances. I'm not sure about it, but the council might not allow the parties to settle the dispute, or they might create hurdle
Yes.
because obviously it could be economically beneficial for them. So considering that thing, I have asked that question ki whether we should be allowed because of some council who will create some kind of hurdle in the settlement of dispute.
And that's going to happen, right? And that's and you hit the nail on the head too. Sometimes it's against counsel's best interest, right? Especially if they're getting in the US they get a percentage of the verdict. And so if they're settling for less at this table, their paycheck's going to be smaller. That really goes to the mediator's skill, I believe, and again, empowering the parties to make these decisions, and that it's the client's decision whether or not they're going to enter into this agreement. Having that discussion up front, again, is really important to make this process work. And there's we call them caucuses, where sometimes I might find it necessary to take the attorney, either one or both, and have a conversation about why this case is not resolving, right? And I tell, at the process discussion, if party, you want to talk to me as the mediator without your attorney present, feel free to let me know. And so again, it's just these communication skills and this practice and the experience. We, again, back to that 40-hour training, right? This is something that you'll have to deal with. I know I deal with some attorneys more frequently than others, and I can tell their negotiating style. And so sometimes working in spite of what that attorney may do.
Right, ma'am. Anyone else have any question? I think they have no question, ma'am.
No more questions.
Yes, please go ahead if you have any question.
All right.
Okay.
So what time is it there? Is it 8
It
o'clock?
is 7:50, ma'am. 7:50.
Oh.
No, not 7:50. It's 7:40.
All right. Well, I hope that you found this informative as we just begin our journey together talking about these concepts. And
Yes.
so I will see you Tuesday.
Yes, ma'am. Thank you so much, ma'am, for your word of wisdom. And I'm sure the participant has understood the topic thoroughly. And by sharing with us your opinion and finding at this present time, it highlighted the need of having mediation and conciliation. So, ma'am, I would like to invite Advocate Dr. Swapnil Bangali, sir, Director of Center for Information Communication Technology and Law at MNLU Mumbai, to propose a vote of thanks.
Well, thank you so much, Abhijit. I hope I'm audible.
Yes, sir, you are.
First and foremost, thanks to Christy ma'am. It's been almost around 5 to 6 years since we know each other. And when she first visited, India, I was lucky to be associated with her, and somehow it got clicked in terms of our interests. And usually, those interests are not only associated with the legal subject matters. No doubt that is a very important facet of our careers, but there was too much of traveling together, and then figuring it out some places and all. So it was a wonderful experience that time. And definitely with her vast experience in terms of mediation and all ADR related subject matters, somehow, some of us might feel it that, in India, that when you see a IT lawyer, a technology lawyer talking about, ADR skills and all, suddenly people will see why you see it this way, because these two areas seem to be slightly long distant areas. But somehow in the last few years we are seeing the opportunity that there is a huge connect with what litigation is coming out in terms of IT. And definitely the core idea of most of the IT companies, as well as those who are working in the field, is definitely associated with coming out with some logical conclusion without too much of wastage of time. And no doubt in future we will see too many things which are associated with this field. I have no doubt in my mind, if some legendary people like Christy ma'am keep on working on those areas and definitely enlighten us with details about mediation and other areas of ADR, it will definitely happen very soon. And as far as today's session is concerned, I must say, from her busy schedule, with her vast experience, with his great skill of delivering sessions, not just for the students which I have seen in the past, also for the judges, because I know for sure that she trains the judges in US, as well as she has been very kind. Even last time when she visited India, she was here to train the judges also here in Maharashtra. So it was a very great experience. And definitely specific thing which I would like to state about today's session is the simplicity with which she tried to explain the whole things. And I always felt this, that sometimes after a point of time when it comes to mediation or arbitration, or most of the areas, once you know that what could be the process, it's somehow to sink in with the person. I think today's session was really sinking it together with what mediation is. Even a person with a very little experience of mediation would easily understand what exactly is happening. So thank you very much, Christy ma'am, for that enlightening session with that much of simplicity and with those great examples and that laughter in between. I liked it too much. Thank you so much. Thank you so much. I take this opportunity to also thank Mr. Nair. He has been a constant support, and he's been constantly associated with MNLU. So I say thanks to him. And obviously, it is my pleasure to also thank our Honorable Vice Chancellor, Dr. Dilip Uke, who has been a constant support and a constant, force for all of us to, figure out different and new areas in law. I would also like to thank our registrar sir, who is again, whenever we demand anything, whenever we want to conduct anything, is always a constant support, always helps out with minute details. And thanks to the entire team of faculty members, as well as the, the anchor here, I would say, Professor Abhijit, has been kind enough to, handle the whole process so smoothly. So thanks a lot, all the participants, for giving your valuable time. And with that, we can say that this is the conclusion of the session. It is pleasure again, and just waiting for the Tuesday so that we can hear you
Keep
more.
going.
Yeah. Yes. Thank you so much. Thank you.
You'll have a wonderful evening.
Yeah. Thank you so much. You have a wonderful day too.